Hello, today we're going to be talking about preparation for trial. There's quite a bit that goes into it. So we're going to go ahead and just get right into that classroom and start discussing some of the things. So for trial prep, um, a lot of the work starts with the paralegal. That's somebody who helps the attorney. So we need to organize and file the materials that we need for trial. It's really important to maintain our organizational skills. So we want to prepare our witnesses, exhibits, demonstrative evidence, that stuff that's going to help us demonstrate. Uh, we need to have a jury selection. There's also the layout of the courtroom, and we have a war room set up for coordination and to discuss things. Also assisting at trial. The paralegal will make sure things are in order. And then also the post-trial activities are often the responsibility of the paralegal. But there's certain information that we should know before we go to court, because there's different rules. Is it a federal court or state court? Is it going to be a jury by trial or by judge? And where will it take place? Do we need to travel out of town, or is it local to us? Will it be a courtroom trial, or especially during COVID, over the internet? How are the proceedings going to go forward? So working with our witnesses is always important. They are a key component to presenting a successful case. They can make or break your case sometimes, because the witnesses authenticate the documents that are placed into evidence. They kind of corroborate things and give the jury some confidence in the evidence that is presented. So witnesses will serve as the compelling storytellers, and they convey basically the heart of the case to the jury. Juries really pay attention to the witnesses. So the right witnesses provide the human context for all the facts presented. Sometimes it seems like just a little story you're hearing until you see the reactions of the people, what they look like, how angry or sad or frustrated can really make a difference. So witness related documents need to be prepared. So you need to have your witness list, know who's going to be witnessing at trial. Pre-trial order preparation is important. So we need to make sure that everybody knows the date. Witness files or kits. So we want to prepare some files for the attorney and witness preparation. Deposition transcripts. And a deposition is kind of when you question each other. It's like a pre-trial thing to get some information so you can start building your case. So that happens before the trial. Depositions are important. You also need your exhibits, summaries, all the discovery that refers to the witness's expertise or knowledge of the event. So declarations, affidavits, sworn statements by the witnesses. We got to make sure that sometimes witnesses can't come to the trial for whatever reasons, health reasons, too far away. So they need to be a sworn statement. And that just verifies that it's from them, basically notarized and sworn. So the database hits and searches, including from external databases like LexisNexis or Google. LexisNexis is used a lot. So if you ever go to law school, you'll get familiar with that. It kind of helps with case law. You're going to want key documents that relate to the witnesses. You got to kind of whittle out the stuff that doesn't really matter, and things that relate to the witness can be important. You need to have your notes, interviews, memos of the fact, and subpoenas. We got to make sure those are prepared so people are subpoenaed to court. Sometimes you can have a notice to appear at trial, and you need to have proof of service. So it has to be served, and you need the proof that it was given to those people. Sometimes you can just post it in the newspaper. Other times you can have deputies deliver it. There's different ways to do that, but you have to make sure that there's some proof of service. And the exhibits that we're going to be using, and those can kind of include demonstrative exhibits. So we just got to collect all that stuff before we go to trial. And There we go. Sorry about that. So expert related documents. If you're going to have an expert testify at court, you need their CV, which is curriculum vitae, or their resume. And that just proves that they have experience, that they know what they're talking about. So a CV can include their professional works. Kind of just makes them seem more professional as opposed to just saying I'm a doctor, I've taught for a while. It kind of proves how professional and how expert they are in the field. So the reports are prepared by the expert for this case. You need to list all your documents that are relied upon by the expert that is in the preparation of the reports. So you need to verify where this information came from. And you're going to want to copy all these documents to make sure that enough people have, like your the prosecuting attorney and defending attorney, they need to have all these things in front of them, and all the publications by the expert that relate to the subject matter of the case. So anything that's important that was written needs to be documented, and using transcripts and deposition designations at trial. So for impeachment purposes or in the place of an absent witness, you got to make sure that the transcripts are available. You can go back to impeach a witness based on the transcripts and certain things that were said. And the transcripts need to be at the courtroom during the trial. So you'll have originals or certified copies in sealed envelopes, just to make sure there was no tampering. Communication with the court. Normally that's with the judge's clerk, and the procedure is essential, and it kind of varies from court to court. That's why it's really important to know, is it going to be an out of town court? Is it state, federal? Just so you make sure that the procedures are followed correctly. So if the parties will use deposition testimony, that's during the questioning, in lieu, which means in place of, or in rebuttal, which kind of means like to bring it back, like part of the argument, to the testimony, those must be prepared. So you need to communicate with the court on the protocol and procedure. How do we go about doing this? Designations are exchanged by the parties, and the parties collect, may object, I'm sorry, they may object to the use of the designated testimony. So just because you had the testimony doesn't mean that they won't object. So sometimes it has to be approved by the judge to be brought forward. And tracking the designations, objections, counter designations, ultimate results is essential. So there's a lot that goes on with it. So the logistics of working with trial witnesses. So you got to have a meeting with them, send a witness file to the witness before you meet with them so that they can review their testimony. They need to know exactly what's going on so they can answer correctly while they're testifying. Coordinate witness trial appearances. Make sure that they're able to be there. Copy and contact information at all times. Make sure that they're notified as well. So expert witness trial appearances, that's when you might need the coroner's testimony or a psychologist's testimony. And those are the expert witnesses. So trial exhibits, we often prepare exhibits. It's pretty much a visual aid, and the deposition exhibits, documents, any objects, whether it's a gun, a bloody shirt, a broken whatever, pictures of a smashed car, demonstrative exhibits where you can demonstrate how things would happen. Public sources of information can be important, and even our external databases. So there's things that we can research, bring it in. So the demonstrative exhibits, to go a little bit more in depth on those are used to demonstrate or illustrate key information to the audience, and the audience is the jury. And the types of the demonstrative evidence can be blow-ups of designated trial exhibits. So you can make some pictures and blow them up. Transparencies are like the overhead projection. Videos, charts are often effective. So our diagrams, animations, sometimes you can recreate something using an animation. And also just the presentations using trial presentation software. So you can prepare whether it's a slideshow, just to make it a little bit more visual so people can understand. Everybody learns differently or understands differently. Some people need visuals, some people are more auditory where it's by how they hear. So the parties also must exchange exhibits and exhibit lists before trial. So to have a fair trial, both sides need to know kind of what you're working with. So the time of the exchange will vary depending on the court. So in federal court, the pretrial filings must happen 30 days before trial. That just gives both sides something to work with, gives them time to prepare. But in state court, it's often due just on the first day of trial. So that's a big difference. But usually federal trials are much more in depth. So all the potential trial exhibits must be authenticated before they are admitted into evidence. So we have to make sure these are legitimate. And as the exhibits are prepared, we must consider how each will be authenticated. And demonstrative exhibits also need to be authenticated in more than one way. So depending on the source and type of information that's used to create them. So the process takes more time than usually people anticipate. So definitely start early because it could take longer than you would think. And you just don't want to be unorganized or unprepared. So organizing these exhibits, we need a numbering scheme, also exhibit labels. So there can be 3 sets of exhibits. So we need to organize them, number them, and keep track of them so we know who said what and what evidence goes with who. So it can be yours, theirs, and joint. So sometimes we both can have something and just use it a different way. Like we can use the same picture, but if I'm defending my case this way, they can still use it the other way, but it's the same exhibit that we can use together. So we need multiple copies that we need to number, label, and there's going to be a master set, which is kind of like the original, and then we make copies of it. So the number of these copies will vary. So there's going to be the counsel table, the workroom, attorney working copies, some for witnesses, judges, jurors. So we want to make sure that the right people have all the evidence and exhibits that they need. So we have to make sure we have enough copies of that. So that is part of the preparation. So we need to have our trial exhibit list, and these have to be exchanged before trial. That is crucial. So usually exchange at the same time as the exhibit exchange. And the format, we got to do it the right way. Definitely check your local rules. You can also check with the county clerk or court clerk to make sure everything is absolutely presented the way it needs to be and validated. So you need a comprehensive exhibit list for use at trial. So there's going to be a different list. It is a different list than the exchange list, and it includes all the exhibits, not just our sides. So that's what the comprehensive exhibit is everybody's exhibits. So we need an exhibit number, description, sponsoring witnesses, who is presenting this, and identifying information with the date range, and the list will be updated as the exhibits are marked and or admitted into evidence. So not everything's always admitted. So there's some technology tools that's kind of nice. So if you have access to these, definitely use it. Don't reinvent the wheel. Use your copy and paste features. Instead of retyping everything, you can use your computer to just copy and paste. Also linking between integrated software, definitely use softwares that can make it quicker and easier. Import and export between applications. So instead of redoing everything, just import it or export it, send it to a new file to make everything cohesive. Maximize your efficiency just by using your computer. You can use data and document storage. It's really good for organization. Also sorting and resorting information. It's a lot easier to do things by resorting on the computer. And it can kind of help us with searching, whether it's for evidence or searching through the transcripts or the depositions to find the information that we need. So litigation, going to trial, trial support technology tools that we must know about. There's a deposition database product that's called LiveNote, and also Summation. It's just an electronic file copy of the transcript, and that can be so useful. If you have that electronic copy, it's a lot easier to search through things. Search within that transcript or even across multiple transcripts. And the exhibits can be linked to the transcript, so you can find things a lot easier. And there's also real-time transcripts that are happening um, as the words are being said, and integrated with other litigation support products. So sometimes there's other products that can help us do our searches. And here we go, more litigation and trial support technology tools. These are things, honestly, if you are in law school, become an attorney or a judge, you definitely want to use this. So the document database products like Concordance or Summation, you just have unlimited fields plus full text, fast and easy search capability, electronic foldering where you can place things into folders, find it easy, annotations, reports, integration with other litigation support products. So there's also a new document database that are web enabled. And these are some examples are Ringtail, FYI for your information, and also Introspect. So there's also hosted database solutions that sometimes can be appropriate. So for very large documents, you can review those, you can review productions, and multiple parties need access to the same data. So if it's through a computer, it's a lot easier to share. And there's applied discovery, all these different kinds. Ringtail is used a lot. And case analysis tools, case map, time map, helps with timelines and the chronological order, how things are, what came first. So it's easier to kind of do our thinking on, does that make sense? Did that happen first or second? Did they say this? Organize any way you like. You could organize it, whether it's by the issue, by the person, the location, however you want to organize it, which is really nice. Integrate with other litigation support products. So it's nice that it can integrate and kind of work alongside other different types of support products. So here you have your trial presentation tools. PowerPoint, that can be very effective. It gives somebody a visual to look at. I make a lot of PowerPoints and they're not all that hard, and they do make a difference in how you present things, whether it's for your organizational skills so you know what to say. It's like a reminder, but it's also something to reinforce in the jurors' minds what is being presented. So you can use different presentation tools. There's Sanction, Trial Director. Those are more featured, and they're also more robust than PowerPoint. So they kind of can get your point across a little bit better than just a PowerPoint. They're a little fancier. So on the fly or unplanned changes in directions are easily accommodated. Sometimes you're like, uh-oh, I need to change that. So you can do that really quickly. Integrated with other technologies. So video, audio can make a difference. So if you have a presentation and you want to have the audio right in it, that can help. So some things to consider, witness and issue files, organized the right way. Also your exhibit list, deposition designations. So we know where we're putting our depositions and what we can collect from them or pull from them. Also our exhibit selection that can help us remember which is which, to organize, like what is exhibit A. It just helps you with knowing the numbering, the labeling, tracking, organization, transcript management. Transcripts are so important. It helps you go back and see things. Sometimes trials are several days. Some can even be years long. So if you have the transcripts and you want to pull something from days ago, if it's organized, or you can do a keyword search, it makes a huge difference. And also your trial presentations, how you're going to present your case. So the use of technology will save a lot of time. It's instantaneous access to the evidence. The illustrations and graphics can shorten your presentation time because you don't have to describe everything. There was a corner with a store and a person crossing the street, and across the street was a dog, and they could just see it and you can point to it. Illustrations, graphics really help. And the electronic display allows the exhibits to be previewed quickly when objections are raised. So if somebody objects to something, you can quickly pull it up and also look at it to see why it's being objected to and if you can counter that objection. So the court might require the use of technology. Sometimes they want a short trial. And so to cut down on wasted time, they might require certain things be presented. The use of technology can also help reduce the expense to the client because they're paying per hour for their attorney, also time off of work, and other expenses can be reduced as well because they are paying for the attorney. So time searching for, retrieving, then refiling paper documents just adds up in cost. Making and maintaining multiple copies can get expensive. Shipping. Instead of just shipping all these transcripts, it's just accessible on a computer. Transportation costs money to ship things or to drive it there yourself. Also the storage. You only have so much storage, then you got to either pay for a larger building or to have it stored somewhere. So inside the courtroom, we must have advanced planning. That is essential. So definitely check with the clerk regarding what will be allowed in the courtroom. So you got to be careful if you're going to bring maybe a gun into evidence. Is that allowed? Does it have to go through certain avenues? So make sure you know any security requirements. Equipment and boxes might need to be delivered during off hours. Like you might not be able to bring them in during regular hours. So you might have to use a freight elevator instead of a public elevator. Also service entrances, they might have a certain place where you're allowed to enter with evidence. So you have to plan extra time for metal detectors, searches. So you can't just rush in there because sometimes it has to go through the metal detectors and that can take time. If they are a little curious if what you're bringing in is safe, they might have to search it. So understand the court's expectations. You might be required to use the court's equipment. So if you want to bring in your own computer, you might not be able to. You might have to share equipment with opposing counsel. So if you have a like an old-fashioned slide presentation with those little discs, and you use a slide projector, they might not let you do that. So you might not be able to bring that in. You might have to use transparencies. So it's always important. You don't want to have your presentation be unable to be shared if you use the wrong items and weren't allowed to bring your own equipment. So some things to take into account, the attorney's personal style. How are we going to interact with each other? Is there a way to push buttons? Is there a way to, get your point across more, where you can be seen as more reliable? So just the way personalities are can make a difference. So you should also familiarize yourself with the courtroom. Where will the attorney stand and walk? What's your location? Where should you sit? Where will the court and jury have the best view of the screen or the display? So you might want to make sure that where you put your presentation is the right place to put it. So know the size and layout so you can decide on the equipment that you're going to use. Also, this is extremely important. Your power or your cabling restrictions. Is there an outlet, or do you need a battery? Do you need uh, extension cord? So physical restraints as to the placement of the equipment. Is there enough room? Am I allowed to place uh, something on a table that will allow the projector to work? So you need to visit the courtroom, map out how the equipment will be placed, because all courtrooms are different. They're different sizes, where the juries sit. So you should be using the court's presentation system, and it's good to be familiar with it. So before you go to court, definitely check your equipment. You don't want a dead battery in your computer, or things that just don't work. Make sure the equipment is compatible. So if you have a certain computer program, you want to make sure that it works on, you just want to make sure it's compatible, that they work together. So test it ahead of time. If you are able to, test it in the courtroom if possible. Maybe ask for early access. So make sure that the projector that you use has a high enough brightness, because you want to make sure that the resolution, how clear and concise the picture is, you want to make sure that's set correctly before you even start presenting it. Make sure your laptop has enough memory, especially if you'll be using video clips or images. And you might even need to bring your own audio system so you can project the sound, because they might not be able to hear it off your computer. So you might need an extra audio system. Selection and placement of these displays are so important. So a large single screen for jurors is often the best. And many experts recommend using a digital projector and just one screen that all the parties and jurors can see. Multiple LCD displays in the jury box are another option, kind of like they each have their own little computer screen that they can just look at. But a lot of times it's good to have just one big screen. And you got to make sure, is your courtroom set up with those LCD displays? Multiple multiple computer monitors in the jury box might also be considered. So maybe each juror has a computer screen in front of them, but that depends on the court. So take backup equipment. So if it's available, there's no snafu, nothing goes wrong. Check on the availability of those power outlets. So don't ever forget to do that, because that can be devastating. So the courtroom logistics, here we go with who will set up the equipment before the trial. Also, we're going to have to work with the bailiff, which is kind of like the police officer of the court. So you have to work with the clerk or the bailiff. Schedule a setup time for the courtroom. Who will operate the system during trial? So if you're presenting, somebody might need to operate it. So you got to figure who's going to operate it. Be sure to schedule some practice time in the courtroom so nothing goes wrong. It goes nice and smooth, because that also gives the jurors a little bit more faith. If you can present something professional, you probably know what you're talking about. But if you're messing up all the time, it kind of loses their faith in you. So will you need technical assistance during the trial? Do you need help with the audio? So if any trial testimony will be videotaped, you're going to want appropriate advanced arrangements, whether it's a court reporter to document the words, a videographer who's going to film it, and the testimony must be in the proper format. So there's a special way that you have to put together the testimony. Also make arrangements to safeguard the equipment, because you're going to be relying on that. You need that equipment. So you don't want it to get misplaced or somebody borrows it or takes it home. It needs to be available for you. So in summary, trials can be the best of times and the worst of times. But to keep your experience positive, always plan ahead. be organized, and all those resources that you have, use them as efficiently as possible. There's so many tools to make it easier, quicker, and more concise for the best outcome at court. So here is your trophy for doing a great job today. Please comment in the classroom 2 things you found interesting or 2 things that you didn't realize you needed to prepare for court. So keep learning, and I will see you soon. Have a great day.